last part of that we're going to talk about regarding your procedural safeguards is the dispute resolution process. And this is the part that parents most need to learn about as far as understanding when schools and parents don't agree, what kind of rights do you have. So we're going to talk about that further in the next few slides. Right now, what we have is some changes that have been put in place since 2004. What used to be in place were just two kind of pieces of this dispute resolution process, which was really mediation and the due process hearing. Two other pieces have come into place that we're going to talk a little bit more extensively about, and that's the due process complaint form and a resolution session. So the first part of dispute resolution, the dispute resolution process in Rhode Island is mediation. It is usually the first, other than what happens at the school level, but really the first more formalized level of the process. And it is voluntary on both parts of the school and the parents. It is not to be used to deny or delay a parent's right to pursue due process if they want to. And it really can be a very collaborative, proactive process. Mediation is encouraged when schools and parents really get to that place where they just can't get beyond it. We have many skilled mediators in Rhode Island that have just done some, great work in being able to move families and districts to a kind of a more collaborative place. It is done, the mediation process is done by someone outside of the school district. So it's done by an impartial, qualified mediator, someone who has all the training. It's not done by anyone in the school district. It is scheduled in a timely manner. And a location convenient to both parents and the school department. Again, this is a process that really works very hard at trying to bring this process to a close. It's usually done within 10 school days from the appointment of a mediator or 15 days from the initial request. Again, we suggest you put something in writing to start that timeline. And it is usually the quickest way to get to a resolution. Most of the other processes take a little bit longer, but the mediation process is usually shorter. The other piece that is with the new regulations that wasn't there prior is the fact that these are now legally binding documents. So that mediation does need to be followed, that there are processes that can take place if a mediation is not being followed and can be used in a due process hearing if needed. So before, what would happen, and I know this from my own personal experience, is, you'd go to mediation and possibly that didn't go the way you'd hoped it was going to go. And so people would just immediately write a letter, I want to go to court, I want to go to a due process hearing. And there would be nothing in between. So you would jump from this place of everyone trying to create this very collaborative opportunity to change, and that didn't work, so we go right to court. What the federal government stated was we need to put some other pieces in place prior to just jumping right into that bit of the process. So they said, okay, instead of this letter, one of the things that we're going to do is we're going to create a complaint form. And this is a state level complaint form that is used by anyone that's going through this process, which really gets very specific as to what it is that we're trying to achieve or what it is that we're having a problem with. One of the things that's really important is that there are timelines again along with this, that whatever goes into this cannot be changed at a later time unless it's agreed upon by both parties that we do have some amendments that need to take place. In that process, it also requires that the school department provide the family with free or low-cost legal counsel. If they do decide they want to take this route, the schools are required to give them information as to, how should they prepare for that? Who can they get help with that with? The content is very specific. It will tie back to regulatory language, and then when that is submitted, there's 15 days to determine if that complaint actually meets the due process complaint requirements. Does it have everything? Do we need additional information? Or does this not really, maybe this needs to go back to mediation because it doesn't really fit that level of criteria. So again, it does kind of, it's not there to slow the process down, it's there to fine tune and formalize that process a little bit more, both for families and for schools. This process of going to a due process hearing is not for the faint of heart. It really needs a lot of pieces to make sure that everyone understands what's going to be happening in this process. So now we're going to talk about the resolution session. And for some, the resolution session has become a really important part of this process of possibly avoiding due process. And let me tell you what my example was, that many years ago, before this was actually put into place, we did go through the process, or start to go through the process of due process, and a due process hearing. And our special ed director sat down with my husband and I and our lawyer and said, hey, before we go any further, you guys can still go through with this, but before we go any further, why don't we have a sit and have a conversation? And so we did. Their lawyers, our lawyers, we had that conversation, and we were able to come to an agreement around my son. And I think there are many other districts that have been doing that kind of process for a while, but not so formally. So back in 2004, when IDEA was reauthorized, the federal government said, you know what? Schools do need to do this. There's a lot of unnecessary money getting spent in these processes that maybe could be avoided, and maybe not just avoided, but really be resolved at the local level. So resolution sessions were put in place. And the goal is, it really is that opportunity to discuss that request. It's the school department kind of reaching the hand out, giving the family an opportunity to resolve the process. But keep in mind that a parent can also just waive it. They can say, nope, you know what, we've done it. Or they can even say, I'd rather go back to mediation. Let's go back and have that impartial person come back in and have another conversation. So again, there's really a lot more layers in place to resolve these discussions. The participants would be certainly the school department. They would convene the meeting with the family. If the family wanted to bring an attorney, the school could also bring that attorney. But again, the school should not be including an attorney unless that parent is bringing one. So parents shouldn't show up and find out that there's an attorney sitting there if they haven't been also bringing that attorney. Again, they have the right to waive, and it's 15 days from that request where the school department should be having that conversation to set up that resolution session. So now we move on to the impartial due process hearing. And again, this is where a lot of, obviously the harder decisions are being made, where there is an impartial hearing officer who is not an employee of the state or the local school department. They cannot raise new issues. So when we go into this hearing, we've already got the complaint in place. So what's really important is we can't be now bringing in new stuff. That information is already now on record, and attorneys will be involved, or for the most part, attorneys may be involved in that process. The timeline for requesting the hearings, you can't go back more than 2 years. That's a new piece. It used to be that you could bring up things from years back, but they have kind of brought it down to, okay, whatever issues we're dealing with need to have happened within this 2-year block of time. Again, parents can certainly be accompanied by an attorney. Parents also have the right to have their child be present. They have the right for that hearing to be open to the public. And that they get they have a right to the record. I get at no cost to me. So if I want a copy of that written record at some point, I can also have that at no cost. The decisions, certainly hearing decisions are being made. And again, this really looks like a regular court of law. There's cross-examination, there are witnesses, there's testimony. Everything of this is like any other typical court setting, and it can become a very arduous process for some families, but yet at times it's also become a very important process for that student. The timeline of the hearing, no later than 45 days after the 30-day complaint period. So that's got to take place. Again, remember I said the mediation was a little bit quicker. This has a little bit longer timeline. And the newer part is that attorney fees can actually be awarded to either side. So that's another piece that parents need to consider when they go into this process. And that the child's status during those proceedings, a child must remain in the current placement. That becomes a very important piece of the due process journey, is that that the student does stay in that current placement until a decision is actually made. So the last piece of the dispute resolution process, and this can be done at any time, this is the state complaint. And this is probably from what I've been told, is the most underutilized procedural safeguard that we have in Rhode Island. If you look at our state complaint processes, there isn't a whole lot out there, but it becomes an important piece. It's an administrative complaint. There is a state form that goes along with that. And the Rhode Island Department of Education has 60 days to investigate that complaint. So they will go and check with the school department. They will issue findings in writing and make sure that not only the school department but the parent also has that information. Again, it must be resolved in 60 days from that receipt of that complaint, and it really does become an underutilized tool for a family, especially when there are times when the process is very black and white. You know, something hasn't been happening, that supports haven't been provided, that timelines have been broken. Everything that we've talked about today certainly could be something that, if it was broken, a complaint form would be a direction to go in. So there's a lot of different pieces of this dispute process. There's a lot of things in place that can be very helpful to families and schools. And I encourage you to, when you're in those situations, to really take advantage of those processes. This has been a very meaty kind of conversation. And however long and complicated any endeavor might be, it always needs to be initiated with something short and simple. So once you get started, just think about one step at a time. Don't think about understanding everything at once, but take it back to the very beginning and look at baby steps. So remember, we hope that one of your goals is going to be to build a healthy working relationship with your school district. With the correct knowledge on how the system works, it's going to level the playing field for you and for your student. This doesn't mean you're never going to have conflict, but hopefully you may have a few more tools that you'll be able to deal with that conflict a little bit easier. If you build that working relationship with the school district, collaborating for a better outcomes for your student, it's going to be much easier in the long run. Good luck. If you need more information, please don't hesitate to call Rhode Island Parent Information Network's Resource Center at 401-270-0101. We look forward to hearing from you.